Okay, I guess we'll get started. Welcome, everyone. My name is Chloe O'Neill. I'm the editor-in-chief of the University of St. Thomas Law Journal. We're hosting this event as our annual lecture. Thank you all for coming. Today we have some really exciting speakers discussing where we are 25 years after the passage of the Americans with Disabilities Act and where we can go from here, basically, both in the law and in the social work profession. First of all, there were programs on everybody's chairs, and inside of those programs is a question sheet. If you have a question during the presentation at any time, just fill out this sheet and raise your hand in the air with the sheet. One of the Law Journal members will come collect those from you, and at the end we'll select a few questions for the speakers to answer. So Professor Bagenstos was supposed to lead the way today, but he had a delayed flight. We expect him to be here for the second hour of the presentation. So we're rearranging a little bit. We're going to have Professor Elizabeth Schiltz from the University of St. Thomas Law here start us off with a bit of a synopsis of what Professor Bagenstos will discuss, and then she will go ahead with her response, and we will have the rest of the respondents go before Professor Bagenstos arrives. Sorry about that. You never can predict plane trouble, unfortunately. So I'll start by just introducing each of our wonderful speakers today. Professor Bagenstos is the Frank G. Millard Professor of Law at the University of Michigan Law School, where he specializes in constitutional and civil rights litigation. He was a Principal Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice, where he promulgated the 2010 Americans with Disabilities Act regulations and also reinvigorated the Civil Rights Division's enforcement of Olmstead versus LC, which guarantees people with disabilities the right to live and receive services in the most integrated setting appropriate. Professor Bagenstos has continued to litigate cases in front of the Supreme Court, including the recent Young versus United Parcel Service case in 2015, which established new protections for pregnant workers, and United States versus Georgia in 2006, which upheld the constitutionality of Title II of the ADA. Professor Stephen Mikochik is a professor emeritus at Temple Law School in Philadelphia, where he taught constitutional law and related courses. Before that, he was also an attorney with the Civil Rights Division of the U.S. Department of Justice, where he worked to enforce the rights of people with disabilities. Currently, Professor Mikochik is a visiting professor of jurisprudence at Ave Maria School of Law, and he is also involved with the National Catholic Partnership on Disabilities, as well as the U.S. Catholic, which implements the pastoral statement on people with disabilities of U.S. Catholic bishops. Professor Schiltz is the Thomas J. Abood Research Scholar and University of St. Thomas School of Law professor. She teaches contracts, commercial law, banking regulation, and conducts research on disability law, among other topics. She's the co-director of our Terrence J. Murphy Institute for Catholic Thought, Law, and Public Policy, and is a member of the board of the National Catholic Partnership on Disability. Professor Schiltz also helped create the disability advocacy website, disabilityjustice.org, and has been involved in the legal theory blog Mirror of Justice. Mr. Backstrom is the county attorney of Dakota County, Minnesota, where he oversees 39 attorneys, prosecutes major criminal cases, and is actively involved in the drug court. He has been outspoken about prosecuting crimes against people with disabilities, and recently prosecuted a major assisted suicide case involving disabled victims. He has established innovative county programs for crime prevention, juvenile crime, and victim services, and successfully argued a case before the United States Supreme Court. He also advocates in front of the Minnesota legislation regarding criminal justice. And Professor Nancy Fitzsimmons is a professor of social work at Minnesota State University, Mankato, where she teaches social work courses in social welfare, policy, and disabilities. She served as the inaugural director of the school's Master of Social Work program and has written extensively on violence against people with disabilities, most notably in her recent book, Combating Violence and Abuse of People with Disabilities. She has written curricula for law enforcement and support professionals and conducts trainings and presentations regarding disabilities issues. And she's on the editorial board for the Journal of Social Work in Disability and Rehabilitation. She's also a former board member and president of the Harry Meyering Center, which is a residential service center for people with disabilities. And she was recently appointed by Governor Mark Dayton to the Minnesota State Council on Disability. Please welcome Professor Schultz as she introduces Professor Bagenstos' topic today.
I apologize for being Professor Schultz rather than Professor Bagenstos, but he will be here. He's determined to get here, and he's going to be worth the wait. So we're like the warm-up act then. And the thing that I'm going to start off with before I start off with my response to Professor Bagenstos is I'm going to try to summarize what parts of what he's going to be talking about, just to set the stage for the responses that you're going to hear and to frame the comments that you're going to hear from us. We have the benefit of having received a summary of his talk. So I'm going to read a couple of its paragraphs, and I'm going to try to weave them together and hopefully not misspeak for him. Professor Bagenstos' talk is called From Integrationism to Equal Protection, Tenbrook and the Next 25 Years of Disability Rights. And this is how he starts off here. If there is one person who we can say is most responsible for the legal theory of the disability rights movement, that person would be Jacobus Tenbrook. The purpose of this lecture is to bring together two of the important bodies of scholarship produced by Jacobus Tenbrook. His disability law work is well known to the disability rights activists and scholars, and his work on the 14th Amendment is well known to constitutional scholars. But no one has really brought those two lines of thought together. Here, I'd like to do that. In particular, I'd like to show how Tenbrook's important scholarship on the anti-slavery origins of the 14th Amendment can help us chart an agenda for the next 25 years of disability rights, just as Tenbrook's scholarship on disability integrationism set the agenda for the ADA in the first 25 years. So, just a little bit about Professor Tenbrook's work on disability rights. In 1966, with President Johnson's Civil Rights Act having been only recently adopted and the battles of the African American civil rights movement still raging, Professor Tenbrook published 2 articles in the California Law Review that sketched out a course of something we did not yet know to call disability rights. These 2 articles were called The Disabled and the Law of Welfare and The Right to Live in the World, the Disabled in the Law of Torts. And these 2 articles set the stage for us seeing disability rights as a civil right. Professor Tenbrook defended in these theories, in these articles, an integrationist theory of disability law. He argued that the American legal response to disability up till then had been marked by custodialism, in which the goal was to protect and to maintain people with disabilities as essentially wards of the state. He also argued, though, that in recent years, American law had increasingly defended a principle of integrationism, in which the goal was to provide people with disabilities the support to enable them to participate fully in the life of the community. None of this sounds radical to any of us today, but it was radical in 1966. And his work led the foundation for the eventual adoption of legislation leading up to, culminating with the Americans with Disabilities Act. The ADA incorporates Professor Tenbrook's policy of integrationism much more overtly than the previous cases had done. And one of the key cases that the Supreme Court has decided under the statute is its 1999 decision in Olmstead v. LC. That case has been aptly described as the Brown v. Board of Education of the disability rights movement. And in that case, the court held that the ADA imposes an integration mandate requiring states that administer services for people with disabilities to do so in the most integrated setting appropriate for each individual. In the decade and a half since that decision, Olmsted has pushed states to tilt away from housing people with disabilities in custodial institutions and nursing homes separate from the rest of the community. Instead, states have begun to build up robust systems of services and supports that enable people with disabilities to live in apartments alongside others in the community, to make basic life choices, to spend their lives in the same activities in which everybody else participates. So, Professor Bagenstos, in his article and talk, indicate that recognizes that the ADA and the legislation that preceded it has been wonderful, resulting in notable gains for Americans with disabilities. He doesn't want to inter Professor Tenbrook's principle of integrationism, but he says it's time to build on it and go beyond it. A lot of the issues that occupy the disability rights movement today, and will increasingly be the focus of attention of the disability rights movement, are not principally about integrationism. So Professor Bagenstos proposes that we need to think about some other aspects of Professor Tenbrook's work that might give us a way to think about where we need to go in the next 25 years. In 1949, Professor Tenbrook wrote an article that he co-authored with Joseph Tussman, also in the California Law Review, called The Equal Protection of the Law. And that article has become one of the most cited articles in constitutional law. It set the stage for the way we think about the Equal Protection Clause of the Constitution today. It's the basic format for how states can classify people in ways that are either over-inclusive and under-inclusive. It is the basic framework through which the pioneers of the civil rights movement in many areas were able to ensure for themselves a better protection of the basic benefits that everyone in society is allowed to, is entitled to. So the understanding of the Equal Protection Clause that governs our jurisprudence today is one that is pretty much well, let me go back to one of his paragraphs here. Okay, Professor Bagenstos is arguing that there's something more that we can find in Professor Tenbrook's work that comes out of his 1951 book, The Anti-Slavery Origins of the 14th Amendment. He says there's another piece of another way that we might be able to understand the Equal Protection Clause that might be something other than just this prohibition of impermissible classifications, which is how we understand it now. As the title of this book makes clear, Professor Tenbrook found and studied the origins of the 14th Amendment in constitutional theories developed by the anti-slavery activists before the Civil War. Professor Tenbrook argues, according to Professor Bagenstos, that a crucial aspect of the anti-slavery constitutional theory was the concept of protection of the laws, which was in turn the root for equal protection of the laws. And this concept was not just about trying to ensure that legislative classifications were reasonable, rational, or sufficiently closely connected to an important interests. He said it wasn't about legislative classification at all. Instead, it was about something much more elemental, the right, which anti-slavery activists considered a natural right, to have the government protect individuals against the depredations of other individuals. Equal protection of the laws was thus an affirmative guarantee of state protection. Here's a quote from Professor Tenbrook. Equal protection of the laws is thus a command for the full or ample protection of the laws. It is basically an affirmative command to supply the protection of the laws. This is its most primary character. Its negative on governmental action is secondary and almost incidental. Now, Professor Bagenstos acknowledges that current doctrine recognizes nothing like this, and this is a different kind of a view that he's trying to propose. He's arguing that if persons are not protected in their natural rights at all, or not as well protected as others, or if citizens are not protected in their privileges and immunities, Congress might have, he's trying to argue, some kind of a right to make up the state's deficiency and give protection. He says it's not going to be his goal in this election to argue that Tenbrook's understanding should be the law, but he wants to explore what the abolitionist understandings of equal protection might tell us about the future of disability rights in America. If the first 25 years of the ADA were driven by the effort to codify Tenbrook's integrationist principle, he argues that the next 25 years will be as much about the effort to heed Tenbrook's equal protection insights. And he is going to be telling us and talking to us about 3 areas of the law in which the equal protection issue seems to be going to be especially important and especially salient for disability rights activists in the upcoming years. And he's going to explain why the theory that he's proposing might be what we need in order to get some movement in those issues. And those 3 issues are issues about which all of our speakers are going to be speaking. One of them, hate crimes against and abuse of people with disabilities. Another one, police use of force against people with disabilities. And then finally, the continued controversy regarding possible legalization of physician-assisted suicide. So those are his 3 case studies into which that he's going to be using. And I'll let him talk about those. I'm going to move into what I was going to say in response to his discussion. And it has a lot to do with his constitutional arguments, so I think it ought to make sense with that little bit of a background, even though he hasn't given us the full explanation of his talk. Okay, so now it's me talking, not me trying to channel somebody else who's much smarter than I am and knows a lot more about this than I am. So now you can just blame me on anything that I say that's wrong. One of the most striking characteristics of all of Professor Bagenstos' work is always that it's very elegant, it's very brilliant, it's very easy to read, but it's also always very, very honest. He never shrinks from confronting head-on inconsistencies or difficulties in the arguments that he's trying to make. And this is abundantly in display in this talk that he's going to be giving us. He illustrates, on the one hand, the extraordinary successes of Tenbrook's integrationism theory, and on the other hand, the limits of that theory. Our own state's successful adoption just last week of our own Olmstead plan is a testament to how far that integrationism theory has gotten us. But the fact that that plan was in response to a court order in the settlement of a case that was brought against the state for mistreatment of people with disabilities in a state institution is testament to how far we still have to go and the limits of the integrationist theories. Sam suggests that the disability rights advocates are going to need this other theoretical tool that we don't really have yet, that we might be able to understand better by looking at Tenbrook's theory that the Equal Protection Clause might give the federal government an affirmative command to supply equal protection of the laws. As he notes, this would require significant expansion of the current understanding of the Equal Protection Clause. What I'd like to do in my short time here is first offer a suggestion for some possible support for Sam's theory from cases leading to the deinstitutionalization of people with disabilities. Then the second thing I want to do is offer another case study for testing whether such a theory might be needed in the next stage of disability advocacy, and that's dealing with voting rights. Both of my ideas are related by their reliance on what I think is a flawed and a dangerous argument, namely that convicted prisoners constitute an appropriate legal analogy to people with disabilities. So first, let me explain how the deinstitutionalization cases might contain some seeds of a Tenbrook-like right to protection. The 1970s saw a series of lawsuits that led first to the reform and then to the eventual closure of horrific state institutions in which people with disabilities were warehoused, abused, imprisoned, and then forgotten. The most prominent of these cases involved state institutions in New York, Alabama, and Pennsylvania. In these cases, the plaintiffs typically asserted a whole panoply of constitutional arguments, and the judges who ruled in favor of the plaintiffs were not always completely clear about which of the constitutional arguments really won the day. But if you look at the opinions in these cases, you can discern, I think, 2 tracks to those arguments. One is the integrationism track that eventually led to the deinstitutionalization of the residents, and with additional support from the enactment of the ADA to the Olmstead integration mandates. That's the track we tend to focus on because it led to what we now see as the most significant result of that litigation, the closing of those institutions. But there was another track to all these arguments that I don't think was ever reversed, and that arguably supports a Tenbrook-like right to protection argument. Let's look first at the New York case involving the Willowbrook Developmental Center. Now, I'm going to read some quotes from some of these opinions, and they're going to use language that we would now find very offensive in referring to people with disabilities. But the people that wrote these decisions were heroes in the disability rights movement, and they were using language that they thought was appropriate at the time, so please forgive me. In the Willowbrook case in New York, the U.S. District Court Judge Judd rejected plaintiffs' arguments that the Due Process Clause guaranteed a right to treatment or that the denial of public education violated the Equal Protection Clause. But he did find that the conditions in Willowbrook violated the constitutional right of persons living in state custodial institutions to be protected from harm. According to Judge Judd, the plaintiff's constitutional right to protection from harm in a state institution meant that the residents of Willowbrook were entitled to at least the same living conditions as prisoners. This right, he continued, quote, may rest on the 8th Amendment, the Due Process Clause of the 14th Amendment, or the Equal Protection Clause of the 14th Amendment, based on irrational discrimination between prisoners and innocent mentally retarded persons. He didn't find any need to determine which basis was determinative, but he did grant the plaintiffs much of their requested injunctive relief, including prohibiting the use of seclusion and restraints, increasing medical, therapeutic, and recreational staffing, and requiring regular progress reports. So this protection from harm that Judge Judd posited was the basis for finding an affirmative obligation by the state not only not to abuse residents, but also to provide medical, therapeutic, and recreational care. In the Alabama case, U.S. District Judge Johnson focused not so much on protection from harm as on integration. He articulated a right to habilitation for patients involuntarily committed to 2 mental institutions and to the Partlow School for people with developmental disabilities. He noted that these people had been, quote, involuntarily committed through non-criminal procedures and without the constitutional protections that are afforded defendants in criminal proceedings. He continued, adequate and effective treatment is constitutionally required because, absent treatment, the hospital is transformed into a penitentiary where one could be held indefinitely for no convicted offense. He justified this right to treatment on a due process theory. He proclaimed to deprive any citizens of his or her liberty upon the altruistic theory that the confinement is for humane therapeutic reasons, and then fail to provide adequate treatment violates the very fundamentals of due process. Judge Johnson's remedies came to be known as the Wyatt Standards, and they set minimum constitutional standards for the adequate treatment of people with mental illness and developmental disabilities. Their focus on the obligation of the state to assist residents to acquire and maintain those life skills which enable him to cope more effectively with the demands of his own person and his environment, those constitute an important step in the eventual adoption of the integration mandate. The third case, then, of this trio involved the Pennhurst School in Pennsylvania. And in that case, U.S. District Judge Broderick found that 3 different and distinct constitutional rights of the residents had been violated. One was the right to habilitation following the Willowbrook and the Partlow cases. Another was a next important step in the move to the integration mandate, a right to non-discriminatory habilitation. Judge Broderick ruled that the segregation of the residents of Pennhurst in an institution in which they have been and are being denied minimally adequate habilitation violated their equal protection rights as guaranteed by the 14th Amendment to the Constitution. But the third right that he found is the one that is the most interesting for us today, the constitutional right to be free from physical harm. Judge Broderick wrote, quote, the retarded at Pennhurst have been physically abused. Lack of adequate supervision has produced an atmosphere of danger to the residents. Occasionally, there have been incidents of staff abuse of residents, including rape and beatings. Hundreds of injuries, both major and minor, are reported every month. Judge Broderick held that the residents of the state institutions for the retarded have both an 8th and a 14th Amendment right to freedom from harm. Quoting Judge Judd in the New York case, he wrote, since the residents are for the most part confined behind locked gates and are held without the possibility of a meaningful waiver of their freedom, of their right to freedom, they must be entitled to at least the same living conditions as prisoners. One of the basic rights of a person in confinement is protection from assaults by fellow inmates or staff. Another is the correction of conditions which violate the basic standards of human decency. So a right to protection was identified in at least the Willowbrook and the Pennhurst cases as something distinct from the emerging right to treatment aimed at habilitation and eventual release from the segregated life in an institution. And as these large institutions closed, there seemed to be less urgency to the right to protection from harm of those still confined. Unfortunately, as we in Minnesota have learned in recent years, that right to protection is still of great urgency for people who are still in state institutions. And as Sam will illustrate so graphically in his remarks, it's still of great urgency to many people with disabilities who live out in the community. When the case of one of Pennhurst's residents eventually made its way to the Supreme Court in Romeo v. Youngsburg, the court affirmed the due process rights based on the same kind of rationale that we've seen before of people who are subject to involuntary confinement, to safety or freedom from bodily restraint. But this opinion didn't address the equal protection arguments at all, thus leaving, I would argue, a nascent right to protection harm track of those earlier opinions open to further development based on the Equal Protection Clause. Now, it's possible that this right to protection from harm is only applicable in situations involving involuntary confinement. So maybe the analogy to prisoners is apt, and the equal protection as classification argument is the only thing that supports it. And if that's how the judges in the Willowbrook and Partlow case framed it, if that's the case, it's not going to help us with a Tenbrook-like right to protection argument. But I'd like to offer 3 counter-arguments. First, the remedies that those opinions justified do not reflect an analogy to prisoners. The Wyatt standards reflect the emerging views that a person with a disability must be provided with support and rehabilitation services that serve as the means by which that person is going to be put into a position to be freed from the institution. This is significantly different from the sort of support and rehabilitation appropriate for a person who will be released to society at a fixed date when her prison term is finished. Second, Judge Broderick's opinion in the Pennhurst case at least hints at a right that is broader than that is shared with prisoners. He describes a much more generalized set of possible harms to people with disabilities and emphasizes the right to protection from assaults by fellow inmates, not just the state workers. Third, and most importantly, people with disabilities, even if confined, are innocent of crimes. The justification for their confinement has no relation to the justification for confining criminals. The Wyatt opinion expressly acknowledges this. Thus, the argument that the only reason we have an obligation to protect people with developmental disabilities from harm is that we also protect criminals from harm makes no sense. Our justification for finding a constitutional right for people with disabilities to be protected from harm must come from some other source, and I applaud Sam's efforts to identify that source and to develop it. The second point that I was going to spend some time on is offering this other test case for Sam's theory on whether people with cognitive disabilities should have the right to vote, but I'm out of time. So I think that what we'll do is just move on then to our panelists and let them start talking about what they would offer with regard to the 3 different test cases that Sam's going to be talking about when he comes and gives his talk. And we'll start off with Professor Makochek.
Thank you. Thank you, Lisa. That was very, very interesting and very creative, I thought, too. Can you all hear me? I use a seeing eye dog. I left her under the table, not because she's unruly. I just didn't want you all to see her lips move while I was talking. I wasn't really prepared to address the constitutional issues in the lecture, but I think it's beyond human nature, particularly the nature of a constitutional law professor, and somebody who was directly involved in the deinstitutionalization cases when I was at the Justice Department, to say that I don't think the constitutional arguments are going to work. We tried very hard to get courts to recognize a right to treatment, right to rehabilitation. We tried very hard to get them to recognize a right to rehabilitation in the least restrictive environment. And although there were some lower court opinions, the Partlow case, Wyatt, Ray Broderick's opinion in Pennhurst and being the prime examples, they were all district court opinions. And once it finally got to the Supreme Court, the Supreme Court actually adjudicated the Pennhurst case 3 times on different issues. But when it finally got to the constitutional issue, they held that there wasn't a general right to rehabilitation. There wasn't even the general right to protection from harm. But there was a right, not an analogy to prisoners, but the idea was if the state takes you into custody, into care, all right, if it takes on the responsibility to care for you, then it also assumes some responsibility to protect you. It's like, you know, you have no obligation to help somebody, but if you assume that Good Samaritan duty, as it were, then you shouldn't be performing it in a grossly negligent fashion. That was, I thought, pretty much what Justice Powell was saying in Youngberg versus Romeo. I'm not certain the equal protection argument works very well either. I do, though, think that the presentation, Sam Bagenstos' presentation, raises a very interesting constitutional point, not under the 14th Amendment Equal Protection Clause, but under state constitutional law. This is an area that's been terribly undermined, not undermined, but underutilized in assisted suicide, attacks on assisted suicide legislation. People go in and really don't talk about state constitutional law and whether an assisted suicide bill would in fact violate the state's own Equal Protection Clause. But let me put that aside, since that's really not what I wanted to talk about today. What I do agree with very much is Sam's idea for the next 25 years of disability advocacy. It's interesting, we went from protecting disabled people to integrating disabled people, and now we're back to the need to protect us. And I think there's a real serious problem. And I think it's particularly for people who are most disabled. And I don't think it's a question of violence. I think it's now a question of survival. Let me very briefly identify 3 areas of threat, and then maybe talk a little bit about some of the response that secular groups and religious groups have taken to assisted suicide legislation. The first is the issue of abortion and fetal anomaly. We know that a very high percentage of fetuses diagnosed with Down syndrome or spina bifida are being aborted. I've seen statistics as high as 85%. We can also, I think, anticipate our ability to detect genetic anomalies increases, that we'll see those percentages for other significant genetic problems. There was an editorial in the LA Times a couple of weeks ago that was very critical of a Ohio bill that would have banned the abortion of Down syndrome fetuses. And I think the editorial kind of encapsulates what I assume is the majority view about all of this. And it said something like, look, under the bill, you couldn't abort a fetus who was Down syndrome, but a healthy fetus you could abort. What sense does that make? And I guess the assumption underlying it was it kind of reverses the order of reality, because everybody knows that a healthy fetus is much more valuable than an unhealthy fetus. We talk about legislation like the ADA that says that disabled people have equal dignity. That rings kind of hollow when society is trying to keep you from coming into society in the first place. If society is saying you're not welcome here, then how can you really talk about equal dignity once you come? Right? That's the first problem, a very serious problem, I think. But even if the child makes it through the birth canal, she's going to face, particularly if she has a very serious disability, a lifetime of the potential of what's being called fetal care. This is when a doctor can make a decision on his own over the objection of the patient or the family that medical treatment isn't medically appropriate. And the most egregious case is in Texas, dealing with a Texas law that was adopted in 1999. And it's a case, a problem that I've been dealing with in terms of that legislation for at least the last 8 years. What the Texas law says is this: if you have a terminal condition or if you have an irreversible condition meaning that it's uncurable, you're on life support, and you're unable to care for yourself or make your own medical decisions, which is virtually going to encapsulate just about everybody on life support, if you're talking about not able to care for yourself, then the doctor, the attending physician, can refuse what he considers to be inappropriate medical treatment. Now, and this is over the objection of the patient and the family, and principally we're talking about refusing to continue life support. Now, it has to be reviewed by the ethics committee in the hospital, but there's no standards. All right? And the problem isn't if experts in the field say that the quality of the treatment is inappropriate because it's not working. The problem is they can make the judgment on the quality of the life involved, and there's no standards. There's not even judicial review. And the problem is, once they make that determination and say, we're not going to continue your life support because we don't think your life is worth living, you've got 10 days to find another hospital that's going to give you the treatment, or they stop it. Okay, and we're talking about stopping life support, so we're talking about stopping life. And you're going to have a lot of trouble finding another hospital because the treatment is going to be costly. You know, I've been toying with whether to mention this, but we also tried very hard when Obamacare was being considered to prevent the Secretary of HHS from being able to rely on research that discounted the lives of disabled people. All right? Without going into any details, I can give you a citation for an article that describes this in full form. But essentially, it's this, the idea is that the Secretary would be prevented to set reimbursement rates on the quality of the life that's being treated. So let's say you have a cancer drug and you have two people. One of the patients is quadriplegic. And the cancer drug is going to extend, based on clinical trials, the life expectancy of both those people for 5 years. The idea of what's called QALY, which is a quality adjusted life year, is that the 5 years for the disabled person, the quadriplegic, don't count the same. They count less than the 5 years for the person who doesn't have quadriplegia. Therefore, the reimbursement rate for that treatment is going to be less. Now, we tried very hard to get part of Obamacare to prohibit the Secretary from being able to rely on those type of clinical studies, and virtually were unsuccessful. There's one provision in there that prevents the Secretary, but in all the other cases where quality measures are used in Obamacare, and I think there's like 23 or 24 cases, we just weren't successful in doing it. So that's another problem too. I mean, if you're subject of fetal care and you're looking for another hospital to give you life support, not only is it going to be costly, but if the hospital isn't going to get full reimbursement for that cost, they're going to be even less likely to provide you that treatment. The final problem I'd like to identify is something I think you probably are aware of, which is the push for assisted suicide legislation. You know that Oregon and Washington State and Vermont all have their own assisted suicide legislation, and Montana permits it based on a court case a few years ago. Why is this a problem for disabled people when all of the legislation, not only the stuff that's been enacted, but the stuff that is being considered, is limited to terminal patients? It always say, look, only somebody who has a terminal condition can get the lethal dose. Why should disabled people be concerned about it? Well, we make a lot of slippery slope arguments, and I think they have some basis, but even without the slippery slope arguments, if you look at the definition of terminal condition that all of these statutes and proposed bills use, it says a terminal condition is a condition which, in reasonable medical judgment, will result in death within 6 months. There's never a reference to life-sustaining treatment. There's never a reference to life support. What does that mean? Well, if you're a disabled person who's dependent on life support, like a ventilator, and you're doing fine, you know, I mean, it's not peachy, but you're doing fine. You know, you can keep on it for the next 10, 20 years. If removing that life support would mean that you would die within 6 months, and obviously if it's life support, you're going to die pretty soon, you're a terminal patient for purposes of all of this legislation. If you're a diabetic and you need insulin to get by, you know, if you're diabetic, you can live a very long life with insulin. But if you need that insulin to keep alive, and if without that insulin you'll be dead in 6 months, you're a terminal patient for purposes of the assisted suicide legislation. All right, so even without talking about a slippery slope, you know, the slippery slope idea is something like this. Look, why do people ask for lethal prescriptions in Oregon and Washington? Well, they're terminal patients. They say that they've lost their autonomy, they've lost their dignity, you know, they've lost their ability to do the things that they used to love to do. All right, so life is kind of meaningless for them. All right, well, those are the same kind of reasons that when disabled people think about suicide, they give for wanting to commit suicide. So let's say you're a legislator and, you know, you've passed assisted suicide for terminal patients because you don't want to see them go through 6 months of feeling undignified, feeling like there are burdens, etc. And now you've got a disabled person, and they're saying, look, extend this to me, because it's just not for 6 months that I'm going to feel these ways. It's for the rest of my life, and my life expectancy is another 20 years. That's a really compelling argument to extend assisted suicide legislation once it's enacted from terminal patients to disabled people, which is why a lot of secular disability groups and a lot of religious disability groups are in the fight to oppose assisted suicide. All right, I don't think I have any time left, do I? No, all right. I'll close here with identifying the threat. And it's a very, very serious threat. And let's hope that out of this conference and the law review, maybe some viable arguments, legal arguments, can be developed to address this threat. Thank you for your patience. Appreciate it.
Well, good afternoon, everyone. First of all, I'm Jim Backstrom, the Dakota County Attorney. My office is located in Hastings, Minnesota. Dakota County is the 3rd largest county in our state. I've been privileged to serve as the leader of that office for the last 28 years. You know, I think as we look at the issues that Professor Bagenstos will be addressing with you, I think it is important to think about just where we were 25 years ago, before the Americans with Disabilities Act existed. And it's important to think about what lies ahead in this important area, because we've come a long way from the misguided policies of segregationism to integrating persons with disabilities into our systems of education, healthcare, housing, public access to transportation, buildings, and so many other services. However, as I know you will hear from Professor Bagenstos when he arrives, we do have concern in many areas that still exist. Professor Bagenstos is going to talk about these 3 case studies, hate crimes against persons, hate crimes against and the abuse of persons with disabilities, the police use of force against persons with disabilities, and assisted suicide that you've heard a little bit about already. I'm going to focus most of my comments today on the first area that Professor Bagenstos will be addressing, and that's the issue of crimes committed against persons with disabilities. For that one relates directly to the work that I do as the Dakota County Attorney, and prosecutors like me across this country do each and every day. One of the truly sad realities of the world that we live in is that some of the most vulnerable persons in our society, those who are living with developmental disabilities, are at a much higher risk of criminal victimization than are others. Yet we hear very little about this problem, and we have a long way to go to fully understand it and to develop tools and ideas to effectively address it. The time has come, I believe, for criminal justice professionals to work together to better understand the dynamics of this serious problem, to establish policies and practices aimed at preventing this abuse from occurring in the first place, and to more efficiently and effectively intervene to address it when it has occurred. Statistics relating to the criminal victimization of persons with disabilities are simply staggering. Persons with disabilities are 4 to 10 times more likely to be abused than persons without disabilities. 68 to 83% of women with disabilities will be sexually assaulted in their lifetime. Children with disabilities are 3 times more likely than children without disabilities to be abused. The likelihood of sexual victimization is even higher for children with intellectual or mental health disabilities. Persons with disabilities experience violent crimes at more than twice the rate of persons without disabilities. Other physical abuse and financial exploitation of persons with disabilities is also far too common. These individuals are often victimized repeatedly, and most of the abusers are known to the victim. Persons with disabilities fall prey to these crimes because they are taught to be compliant. These individuals are often unable to defend themselves, and they're more prone to accept improper advances without questioning or understanding the potential sinister motive behind them. Some persons with disabilities have limited communication skills, and they are often unable to describe what was done to them and by whom. Many of these victims are often isolated, dependent on a small number of people, and some do live in segregated settings such as group homes. And these are additional reasons why this population is victimized at such a high rate. Another sad reality is that far too often crimes committed against persons with disabilities go unreported. This is often due to fear of retaliation or loss of care if the victim were to report the crime. Limited advocacy resources on behalf of these vulnerable victims, including the lack of access to lawyers, is also a factor involved in the underreporting of these crimes. A disability can affect a person's mental functioning, such as the ability to reason and use good judgment, and this can also lead to the victim not reporting the crime. Crime victims with disabilities may also be embarrassed by what was done to them, and many unjustifiably blame themselves for what occurred, which can also lead to the failure to report the crime. Some may not even realize that they've been victimized due to lack of judgment or impaired cognitive abilities. Many are fearful and untrusting of police and prosecutors, and most do not fully comprehend the intricacies of the criminal justice system. Prevention of crime is always a main priority, It is important to provide education to persons with disabilities and their families about appropriate safety precautions to take regarding activities they're involved in, including dangers associated with the use of the internet, proper management of their financial resources, and who to call for help if they need it. However, when prevention fails, it is important to work towards achieving full inclusion and full participation in the criminal justice system of all crime victims, including those with disabilities. Networking and cross-training among criminal justice agencies and victim assistance programs is critical. Networking allows timely information and ideas to be shared with individuals specializing in disability rights. It is also important to spread the word in churches and schools and in public forums like the one that brings us here today, so more people are aware of the issues and available resources. When crimes against persons with disabilities occur, appropriate interviewing and intake procedures should be set in place. It is important to investigate these crimes and interview victims with disabilities just as in any other case, because improper interviewing substantially limits the chances of a successful prosecution. Law enforcement personnel may believe that a person cannot be interviewed because of the severity of that person's disability, such as speech or communication problems. But intellect, however, is often unaffected in persons with such issues, and interviews need to be attempted utilizing family members, social workers, and caregivers to assist if needed. Criminal justice agencies need to assess on a case-by-case basis potential accommodations, including the use of assistive technology and interviewing crime victims with disabilities. This will help these vulnerable victims to better communicate with law enforcement officers, with prosecutors, judges, and victim advocates. When investigating crimes against persons with disabilities, it is important for law enforcement investigators to take special steps to ensure that they provide extra support and treat with sensitivity crime victims who have disabilities. This includes teaming with child or adult protection workers or other advocates in the investigative and interview process. First and foremost, it is important at the outset to make it clear to the victim with a disability that what has occurred is not their fault. It is also important to take extra precautions to help reduce the stress and anxiety that a victim with disabilities will likely have when speaking to an investigator or a prosecutor. Consideration should be given to meeting with the victim at his or her home or group residence so the victim feels more comfortable and at ease. And while it is important to assess the ability of victims with disabilities to understand and follow instructions, it is equally important to let the victims speak for themselves. Prior to trial, a prosecutor should take extra time to provide a victim with disabilities with a tour of the prosecutor's office, the courthouse, and the courtroom to help reduce the victim's fear and anxiety. The prosecutor should address directly with the victim any fear he or she may have about seeing the defendant in the courtroom and any other safety and security issues the victim may have concerning the case. One relatively new and exciting aspect of providing additional support to vulnerable victims during interviews or contact with the victim at the prosecutor's office or during trial is the use of support animals, specifically dogs. It's like the one you see sitting here with the professor. These dogs are specifically trained to help put these vulnerable victims at ease. Several prosecutors across our country have already begun using dogs in this manner, and such animals, it's really truly amazing. I've watched some videos and I've seen these animals firsthand. It's truly amazing to see how much more at ease a victim with disabilities or a child victim or witness becomes when a courthouse dog is sitting next to them during interviews or during a trial. As I believe Professor Bagenstos will suggest, prosecutors should be encouraged to use hate crime statutes or other specific statutory provisions to charge defendants who commit crimes against persons with disabilities or to enhance the penalties for such crimes upon conviction. In Minnesota, there are a number of specific crimes related to victims with disabilities. And while I don't have time to go and discuss all of these with you here this afternoon, I have included this list in an article I have written in conjunction with this forum. During a trial involving a victim with disabilities, it's important for the prosecutor to request the judge to allow for appropriate courtroom accommodations to make the victim or witness feel comfortable in the courtroom setting. Such accommodations could include providing sign language interpreters or other communication enhancement accommodations whenever necessary, allowing the presence of a support person or a pet, as I mentioned, or a stuffed animal to be near the victim or witness with disabilities while they're testifying, using a modified oath, which is more easily understandable to a victim or witness with disabilities, making modifications to the setup of the courtroom itself, such as allowing a victim with disabilities to testify at a table located in front of the bench rather than from behind an intimidating witness stand. And if necessary, it's important to allow attorneys to use leading questions in eliciting testimony from a victim or a witness with disabilities. If appropriate, a prosecutor should also discuss with a victim with disabilities restorative justice options relating to the crime, which could include the requirement for the offender to participate in group conferencing, circle sentencing, or restorative justice panels with the victim present. Such innovative sanctions, which are coming to be used more frequently in our criminal justice system, may well help a victim recover from the trauma that has been inflicted upon them. But caution must be exercised, however, to ensure that this is something that the victim wishes to do, and that these type of meetings with the offender will not cause further trauma. Finally, I believe it is important, extremely important, that sensitivity training be made available to those who work with crime victims with disabilities on an ongoing basis. These include law enforcement agencies, prosecutors, probation officers, and others involved in the investigation, prosecution, and disposition of these types of cases. Such training should include specifics on the difficulties and challenges associated with victims who have disabilities and other unique aspects associated with cases of this nature. As to the second issue that Professor Bagenstos will be addressing in terms of his case studies, the unjustified use of force by police officers against persons with disabilities. It's kind of a hot topic against persons without disabilities in this country today as well. I will just say this. Police officers have a very difficult job. They put their lives on the line every day and are often confronted with persons under the influence of drugs or alcohol or who are in the midst of a mental health crisis. I agree that more training is needed to ensure that our law enforcement officers better understand various disabilities and ways to de-escalate, whenever possible, dangerous situations involving their interactions with persons with disabilities and those without. If time permits, adult and juvenile protection workers and mental health professionals should be available to assist the first responders in these situations. But the reality of the matter is, this is often not possible when a dangerous situation or crisis unfolds. Finally, as to the third issue that you will be hearing from Professor Bagenstos about, and it's already been discussed a little bit by Professor Mikachik, the issue of assisted suicide. This is a matter, as you heard from Chloe when she introduced me, that I have been on the forefront of addressing here in Minnesota. Earlier this year, my office was the first prosecutor's office in the nation to convict Final Exit Network of assisting in a suicide in violation of state law. This is a national right to die organization, used to be known as the Hemlock Society. They believe that they have the right to assist anyone who's suffering from chronic pain or serious illness to take their own life, regardless of whether their condition is terminal. I believe that what this organization does is both legally wrong and morally reprehensible. It's wrong for this organization to counsel and assist persons to kill themselves without adequate safeguards and protections in place to ensure that the person wishing to die is competent to make that decision to require involvement of the individual's family in the decision-making process, to ensure that such deaths occur under the supervision of medical professionals, and that they occur only in cases where a person is in fact terminally ill. Final exit networks activities incorporate none of these protections. They encourage people to kill themselves by pulling a bag over their head and filling it with helium. And they clear out all the evidence of what has occurred to make the death appear to be from natural or unexplained causes, hiding the truth of what actually happened from law enforcement, from the medical examiner, and most importantly, from the victim's own family. By the way, they promote the use of helium as a means to die because it is undetectable in an autopsy. This organization exists. They're operating every day in this country and every state in America. And I think we all need to be aware of what's going on. It's really kind of hard to believe. So as I come down on this issue of legalizing assisted suicide, as several states have done, I do agree with Professor Mikacek that there are some troubling aspects of this question, particularly as they relate to persons with disabilities. And it's important that all aspects of this question be aired in front of the state legislature, if in fact that is what the citizens in our state wish to have approved through their elected legislative leaders. Because that's the only way it should happen. It shouldn't happen through clandestine organizations like Final Exit Network. And if assisted suicide is allowed to occur, it should only be sanctioned, in my view, in cases of terminal illness and with the types of adequate safeguards and protections that I previously mentioned. So with that, I want to thank you for the opportunity to be here tonight, and I will turn it over to your next speaker.
Good evening. I cannot respond to Professor Bagenstos' legal issues. I'm not a legal scholar. I hope to provide a perspective that is not mainstream in popular or professional discourse. And I may say a few things that in some respects parallel what Mr. Backstrom has talked about. The criminal justice system has been described as the last frontier of integration for people with disabilities, despite the fact that evidence supports that people with disabilities experience rates of crime victimization at much higher rates. I usually walk around, so this is not easy for me to stand right here. The most recent Crimes Against Persons with Disabilities report by the Bureau of Justice Statistics, collected through the National Crime Victimization Survey, estimated that the rate of violent victimization against persons with disabilities was more than twice the age-adjusted rate for people without disabilities. The rate of serious violent victimization, rape, sexual assault, robbery, aggravated assault, for persons with disabilities was more than 3 times higher than the age-adjusted rates for people without disabilities. People with a cognitive disability, people with intellectual disabilities, have the highest violent victimization rates. As with the collection of any data, it is important to understand the limitations of the methodology. One such limitation is the data is based on non-institutionalized U.S. residential population. This means that people living in congregate care settings are not represented. People with disabilities living in group homes are included in the sampling protocol, but believed to be significantly underrepresented. Given that we know paid caregivers are among the perpetrators of victimization against people with disabilities, it is reasonable to conclude that the rates of violent victimization are much higher. It is tempting to focus on the numbers, yet in my experience, numbers do not change belief systems or move people to action. This lecture is about the denial of people with disabilities equal protection under the law and full participation in the mainstream of society and its institutions. The numbers will not tell this story. It is important to examine the concept of disability. First, there is no uniform definition of what constitutes a disability. With the advent of modern medicine, using a process of diagnostic assessment, people with disabilities are categorized and are ascribed labels, also known as the medical or scientific definition or model of disability. The medical model of disability focuses on impairment, deficiency, deviance from the norm. It is a deficit-based model. We know that the very act of classifying and labeling contributes to significant disadvantage for people with disabilities. Tenbrook and Mattson rightfully examined the disadvantage perpetrated upon people with disabilities when in professional and popular thought, we talk about disability in broad, generic terms, failing to make the necessary distinction among the varieties of disability and within categories. The phenomenon of diagnostic overshadowing focuses on how, in the health context, there is a tendency to attribute health problems to a person's disability. This tendency of focusing solely or primarily on a person's impairment finds resonance in the criminal justice system, where the victim's disability often overshadows the crimes that have been committed. This process of classifying, ascribing labels, and diagnostic overshadowing are especially egregious in segregated, inaccessible, and non-inclusive societies, communities, and systems that make up our communities. Without opportunities for people with disabilities to counter and challenge what are most often deficit-based belief systems, diagnostic labels and overclassifying take on a life of their own in the minds and actions of others. The medical or scientific orientation to disability reinforces and perpetuates custodialism. Disability rights self-advocates and allies, past and present, challenge an over-reliance on the view of disability from the medical model, what I would contend remains the dominant view of disability among popular and professional thought. The social or cultural model of disability better reflects the lived experiences of people with disabilities. Thus, disability must be understood in the broader societal context. Tenbrook and Mattson write, for the most part, and this is in 1966, for the most part, it is the cultural definition of disability, rather than the scientific or medical definition, which is instrumental in the ascription of capacities and incapacities, roles and rights, status and society. They go on to distinguish the difference between disability and handicap. A handicap is the cumulative results of the obstacles which disability interposes between the individual and his or her maximum functional level. In plain language, the disadvantage or handicap of disability is less about the differences in how the brain or body works, rather it is societal barriers, whether they are physical, programmatic, or attitudinal, that are most debilitating for people with disabilities. Tenbrook and Mattson wrote, the psychological and socioeconomic hardships experienced by people with disabilities are largely a product of the sociocultural definition, an assumptive framework of myths, stereotypes, aversive responses, and outright prejudices. Perhaps the most pervasive, destructive, and debilitating assumption is that which equates disability with vulnerability. Vulnerability implies weakness, dependency, liability, and a need for protection. In essence, a custodial response. Vulnerability to victimization is viewed as part and parcel with having a disability. And remember, I'm using disability in its broadest of context. Despite the fact that vulnerability to victimization is part of the human condition, failure to recognize vulnerability to victimization as part of the human experience reinforces the notion that vulnerability for people with disabilities is somehow fundamentally different than the vulnerability of people without disabilities. For people with disabilities, vulnerability is almost universally associated with individual factors that reside within the person. The impairment in cognitive, physical, sensory, and psychosocial functioning. As a society, past and present, we tend to take an individualized notion of impairment and incapacity, ignoring that vulnerability exists within relationships, within social environments, and within the larger social, political, economic, and cultural context. In 1994, Dick Sobsey wrote what remains the seminal book on victimization of people with disabilities, Violence and Abuse of the Lives of People with Disabilities, The End of Silent Acceptance. Sobsey proposed the integrated ecological model of abuse, which is a system-based model for people for both understanding and preventing victimization of people with disabilities. Halamatz adapted Sobsey's work to develop an ecological model of risk of sexual violence. And you want to think about concentric circles. Both models examine the complex interplay between the individual in relationship with people within their immediate social networks, within the larger environmental context where people live, neighborhood, and where people learn, work, recreate, and worship, community, and within the larger society and culture. Both of these ecological models acknowledge that people with disabilities, to varying degrees, are vulnerable to victimization due to limitations resulting from individual impairment. However, the real disadvantage for people with disabilities, I would contend, is that individual vulnerability is maximized and perpetuated by disempowering and debilitating practices of people, environments, and systems. Yet for people with disabilities, the ecological conceptualization of vulnerability to victimization is not the dominant popular or professional view. Most of the individual characteristics that are believed to make people with disabilities more vulnerable are not personal attributes or inherent traits of the person. For example, being helpless is an attribute often associated with people with disabilities. Is helplessness inherent to people with disabilities? The evidence does not support this assertion. Helplessness is learned, but too often our educational system and disability social service system train children and adults with disabilities to be compliant. Learned helplessness, reinforced by compliance training, leads to learned compliance, and many contend leads to very nice, easy victims. Furthermore, skills needed for self-defense, sexuality competency, and self-determination, all components of risk reduction, are typically not afforded to people with disabilities, especially people with intellectual and developmental disabilities. Such skills are shaped and developed through information, lived experiences, and learning opportunities throughout one's lifetime. Past and present, the predominant response to crime victimization of people with disabilities is a social service response, not a criminal justice response. And I'm a social worker, which I think gives me some license to criticize the various systems that social workers may work in. APS is an outgrowth of the child protection system, created to assess and investigate the social and protective service needs of adults 65 and older, and morphed into including vulnerable adults 18 to 64. The adult protection system, cumulatively created out of public policy emanating from state legislatures, is a custodial response to crime victimization of people with disabilities grounded in the belief of their inherent vulnerability. APS is founded on a caregiver stress model to explain the victimizations of vulnerable adults. The model views caregivers as overburdened and in need of respite and supports. When working from this model, sympathy then may lie with the perpetrator. Mainstream media reinforces this notion of burden by characterizing people with disabilities as suffering from their conditions. If people with disabilities are suffering, then by proxy, the people in their lives must be suffering as well, resulting in sympathy for perpetrators. Alleviate the stress, and victimization will cease. Children are taught to dial 911 in the case of an emergency. Vulnerable adults with disabilities and people who suspect or witness maltreatment, abuse, or mistreatment, the language of adult protection, are instructed to call an abuse reporting center, or for recipients of disability services, reports of incidents initiate an internal agency reporting process that leads to notification to a state agency. The assigned state agency initiates their own investigative process that may include involving law enforcement if the incidents rise to the threshold of a crime. In most states, adult protection is the first responder to abuse, neglect, and exploitation of vulnerable adults. One could argue that our protection systems thwart the ability for people with disabilities to be recognized and responded to as constituents of the criminal justice system. What does it say about the value of people with disabilities in our society when the predominant, publicly sanctioned, and publicly funded response to crime victimization of people with disabilities is a social service response embedded in public health, social, or human service systems? This is hardly in accordance with Tenbrook's vision of integration and equal protection under the law. The prevailing belief in the inherent vulnerability of people with disabilities, meaning that the vulnerability resides within the person as a result of his or her impairment, has not led to people with disabilities being a priority within the criminal justice system, or even deserving of proportional representation. I speak of proportional representation as crime victims, not as offenders. Why might this dichotomy exist? Edwards draws from the discipline of victimology and the victimological other in an attempt to explain why people with disabilities do not make an ideal victim within our society or the criminal justice system. The victimological other refers to the person who does not readily fit into perceived norms about who or what the victim of crime should look like or how they should behave. Edwards, drawing from the work of Christie, suggests that there are two key traits of the ideal victim. He or she must be both vulnerable and not to blame for his or her victimization. Furthermore, the notion of the ideal victim implies that there's an ideal offender, someone who more than often is not a stranger. For more than often is a stranger. People with disabilities, perpetration of crime victimization is overwhelmingly committed by someone in his or her immediate social network, parent, partner, sibling, friend of the family, a paid caregiver. The notion that a caregiver would intentionally harm a person with a disability challenges our notion of the ideal perpetrator. Second, the assumption may be that people with disabilities are non-deserving victims. This thinking would fit with the belief system that people with disabilities are weak, frail, helpless, and innocent, and if so, not culpable for their own victimization. Yet the history of treatment of people with disabilities tells a far different story. Warehousing in institutions, segregation, forced sterilization, genocide, medical experimentation, and viewed as labeled as menaces to society. What Tenbrook and Watson refer to as collectively known as deviant. While the attitudes and treatment of people with disabilities no longer represent such egregious and widespread violation of basic human rights, protection and advocacy organizations from across the United States can attest to the many ways that people with disabilities are victimized. The inhumane treatment at MEDO, the Metropolitan Extended Treatment Options Facility in Cambridge, Minnesota, documented in the report Just Plain Wrong, Excessive Use of Restraints and Law Enforcement-Style Devices, written by our Minnesota Ombudsman for Mental Health and Developmental Disabilities, clearly documents that people working at the facility saw the residents as deviant, deserving, and ultimately responsible for their own victimization. Furthermore, the widespread practice in children and adult disability services of labeling people with disabilities as having behaviors, common parlance, necessitating corrective action on the part of authority figures does not bode well for people with disabilities being seen as ideal victims. The legal system represents the collective will of the people, the state. When a crime is perpetrated against an individual, the state must determine whether or not the offense rises to the level that our public sensibilities are enraged or at least sufficiently troubled, and that the time of our public servants, criminal justice professionals, and public dollars merit our investment to express public indignation, hold offenders accountable for their actions under the law, and seek justice. If people with disabilities are not integrated, rather invisible in our criminal justice system, it is because this is a choice we as a society have made. Thank you for the opportunity to contribute to this conversation. Let me close with the thoughts of a modern-day disability and civil rights activist, Judy Heumann. All perpetrators ask is that the bystander do nothing. He or she appeals to the universal desire to see, hear, and speak no evil. The victim, on the contrary, asks the bystander to share the burden of pain. The victim demands action, engagement, and remembering. Thank you.
He's on his way. So why don't we take some questions in the meantime here? I think we've already got some from the audience. Okay, I'll go ahead and pose some of the questions that we've gotten from the audience. What do you, this is from anybody here, for anybody, what do you see as the top 1 to 2 things that the state of Minnesota could do to improve the lives of people with disabilities?
I'm going to opt out because I'm not a Minnesotan.
So we could probably generalize, probably the state of Minnesota isn't that different from many other states in the nation, but do we have any other thoughts?
Well, I think, as I mentioned in my comments, we need more training, clearly for in the law enforcement field, in terms of interacting with persons with disabilities. We've come a long way, but we still have a long way to go. So I think that's extremely important. And I guess just to comment briefly on Professor Fitzsimmons' remarks, you know, we have a very active child and adult protection system in our state and in our nation. I think it's critical to the safety and well-being of children and vulnerable adults that we have that system in place. But we have come a long way because, you know, 25 years ago when I became the county attorney, there wasn't much interaction between child protection and law enforcement on investigations involving vulnerable adults or children. Today, we have collective investigations. We are mandated, quite frankly, to work together in those areas. And we, in many counties, including mine, we have joint teams that get together and analyze these cases. So I just wanted to make a point that that these investigations are often occurring concurrently, and they need to. And yes, when possible, we need to prosecute these individuals. Now, the one difficult thing to do, and I guess you need to all keep this in mind, you know, in order to prosecute someone for a crime, regardless of whether it's a victim with disabilities or not, we have to have evidence that a crime occurred. In fact, we have to have enough evidence to prove that crime beyond a reasonable doubt in a court of law. That's a very high burden of proof. It's not easy to meet that burden of proof. It should not be easy to convict someone of a crime. But we need to gather the evidence, and it's a little bit more difficult in cases involving victims with disabilities, particularly cases that, and I've seen some really tragic situations where victims have been victimized by caregivers in victims who are extremely disabled and simply can't describe what happened to them. It's not that easy to be able to do that, and we have to have a reasonable belief as a prosecutor that we're going to be able to convict that person beyond a reasonable doubt before we put their name on a criminal complaint as a defendant. So I just want you to keep that in mind.
I think that Steve wanted to say something?
I was curious, Jim, maybe you can answer this for me. The California legislation that's on Jerry Brown's desk, the assisted suicide legislation, one of the provisions says that the documentation that the attending physician has to present to the Department of Health, and that would include the written request. It would include for the lethal dose. It would include if the doctor happened to be an observer to the ingestion of the lethal dose, what happened, all of the medical records. The California bill says none of that is discoverable. And it's not discoverable even in a criminal investigation. It's not discoverable in any administrative proceeding. And I'm not a criminal lawyer at all, but I kind of thought that that would be really inhibiting for a prosecutor. And that, given the fact you're a prosecutor, I just wanted to see your opinion on it.
Well, I would agree, Professor, that if we can't discover the information, again, we don't have the evidence to even look at to consider a prosecution, assuming there was some abuse of the system that took place. But the one thing that is clear to me, and I am not familiar specifically with what law is on Governor Brown's desk in California regarding this issue, but there needs to be really significant protections put in place in any legislation regarding assisted suicide to protect the vulnerable, the disabled, people who are seriously depressed, that can't make these decisions themselves. There has to be protections in place, and that's that to me is clear.
What would you say if you had a procedural system, say in assisted suicide, which lets an interested party, financially interested party, be one of the witnesses to the written request for the legal dose? If it also permits that interested party to be the only person present when the legal dose is taken, and which requires the attending physician to list as the cause of death the underlying medical condition and not taking the legal dose. What would you think about those as protecting the real choice on the part of the person who chooses assisted suicide?
Doesn't sound like a very good system to me. I mean, you cannot have these types of things take place that are not conducted by a physician in the presence of a physician. I don't think that should ever happen. But, you know, obviously you need to have the individuals in the family involved in the discussion about whether this is the right thing to do. As I mentioned, for non-terminal cases, I don't even think it should be on the table to talk about. But you raised some really good points that I actually hadn't thought about. You know, questions about when does something become terminal, and can that be impacted by someone who wants to make this decision because of the lack of medical care? So, I mean, there's a lot of questions about this issue. This is not a very simple issue to resolve, and that's what scares me a lot about what's going on in society. Here's our cue speaker.
Thank you. Thanks a lot.
So, ladies and gentlemen, we've been busily debating the work of somebody who is now here to defend himself. So, I think we'll turn the podium. Turn the podium right over to Sam and let him get started.
Thank you. Thanks very much. Very good to meet you. Oh my goodness. Yeah, so I planned it like this because I like to make an entrance, and I had no idea actually this is how it was going to work out. But I really appreciate people staying around. I appreciate everybody flipping the program around for me, and I see I have exactly half an hour to talk, so I will try to talk quickly, which is not usually a problem for me. So I really, really, really appreciate the opportunity to be here to talk about the next 25 years of the disability rights movement. I think this is really an incredibly important time for the American disability rights movement, and I really appreciate the folks at St. Thomas and at the Law Review, at the St. Thomas Law School for inviting me here to give this talk. The last time I was in this building, I don't know how many years ago. The Eighth Circuit was sitting here, and I argued a case in the Eighth Circuit in this building, and actually a disability rights case that we were trying to get the Eighth Circuit to dismiss because we were afraid they'd rule the wrong way, and they did dismiss, so I appreciate that. So I chalk that up as one of my great litigation victories, avoiding a decision. But so I feel I have such warm feelings about this place and really appreciate the invitation. Let me just sort of jump right into it. I feel odd because I know you've heard some of what I'm going to say, and so I hope that I can keep you interested, notwithstanding that. The title of my talk is From Integrationism to Equal Protection, Tenbrook in the Next 25 Years of Disability Rights. And it's basically trying to bring together the disability rights and the constitutional work of Jacobus Tenbrook, who is sort of well known in both the disability rights and constitutional fields, but constitutional law scholars don't really talk about his disability law work and vice versa. So I sort of wanted to bring it together. And, you know, I guess I'd start here by just saying if there is any one person who we can say is most responsible for the legal theory that undergirds the American disability rights movement, it's Jacobus Tenbrook. He was an influential scholar of disability law whose writings in the 1960s laid the groundwork for the disability rights laws that we have today. And he was also an influential disability rights activist. He was one of the founders and the president for more than 20 years of the National Federation of the Blind, which was one of the first and for many years undisputedly the most effective organizations made up of people with disabilities that fought for the rights of people with disabilities. shockingly limited even today in terms of the number of organizations that fight for the interests of people with disabilities that are made up of people with disabilities. Yet in the legal academy at large, Professor ten Broek is best known not for his disability law scholarship, but for his other work, notably on poverty law, where he was one of the architects of the welfare rights movement, and especially on the 14th Amendment. And the purpose of this lecture is to bring together two of the important bodies of scholarship that he produced. His disability law work is well known to disability rights activists and scholars, and his 14th Amendment work is well known to constitutional scholars. I was teaching Plessy versus Ferguson today in my constitutional law class, and I was teaching the abolitionist constitutionalism that preceded it, and in the casebook I teach, Professor ten Broek's work appears very prominently, but nobody's really brought the two lines of work together, and so that's what I'd like to do. I'd like to show how Professor ten Broek's very important scholarship on the anti-slavery origins of the 14th Amendment can help us chart an agenda for the next 25 years of disability rights, just as Professor ten Broek's scholarship on disability integrationism set the agenda for the ADA and its first 25 years. So let me start with the first 25 years and even the prehistory. In 1966, with President Johnson's Civil Rights Act having only recently been adopted, and the battles of the African American civil rights movement still raging, Professor ten Broek published 2 articles in the California Law Review that sketched out the course of something that we didn't yet know to call disability rights law. The articles were entitled "The Disabled and the Law of Welfare" and "The Right to Live in the World, the Disabled and the Law of Torts." And they defended what Professor ten Broek called an integrationist theory of disability law. And I know, because I've been following the tweets, that you've been talking a little bit about this and hearing a little bit about this today. I had internet on my plane, so I've been following the proceedings. Professor ten Broek argued in these articles that the American legal response to disability had previously been marked by what he called custodialism, in which the goal was to protect and maintain people with disabilities as essentially wards of the state. But he also argued that in recent years, recent as of 1966, American law had increasingly defended a principle of integrationism, in which the goal was to provide people with disabilities the support to enable people with disabilities to participate fully in the lives of the community. It's easy to draw a very direct line between Professor ten Broek's principle of integrationism and the Americans with Disabilities Act. Each of the pieces of legislation that laid the groundwork for the ADA rested on that principle. Professor ten Broek's own Right to Live in the World article lauded the state-by-state adoption of white cane laws, which imposed duties on drivers to accommodate blind pedestrians who walked with canes. The purpose and effect of those laws, of course, was to guarantee that people with disabilities, in this case blind people, could maneuver in society with everyone else and without caretakers accompanying them every step of the way. And actually, Professor ten Broek's article is incredibly moving on the idea that the goal should be for blind individuals or other individuals with disabilities to be able to go about the world and engage with the world just like everybody else. They really were, these white cane laws, the very first American disability rights statutes. And they were quickly followed by a wave of federal legislation. The Architectural Barriers Act of 1968, which was the first federal disability rights law, opened up government buildings so that people with disabilities could have independent access along with everybody else. In 1973, the Rehabilitation Act applied disability non-discrimination rules to all federally funded programs and activities, and therefore extended the same integrationist principles to healthcare, education, transportation, and the workplace in many cases. And the basic idea behind the Rehabilitation Act's crucial Section 504 was to create a disability rights analog to Title VI of the Civil Rights Act of 1964, which was the statute that was central in ensuring integration on the basis of race in our nation's public schools. 2 years after the adoption of the Rehabilitation Act, when Congress adopted the Education for All Handicapped Children Act, now called the Individuals with Disabilities Education Act, integrationism was at the center of the statute. The law required schools to serve children with disabilities in the, quote, least restrictive environment, unquote, a requirement drawn from earlier constitutional litigation that had been brought by civil rights lawyers who explicitly sought to apply the principles of Brown v. Board to disability. The words mainstreaming and later inclusion became the crucial buzzwords of the statute. And the final piece of pre-ADA federal disability rights legislation was the 1988 amendments to the Fair Housing Act. Those amendments made a number of changes to strengthen that landmark 1968 law. One of the changes was, for the first time, to prohibit housing discrimination based on disability. The Fair Housing Act, like Brown and Title VI, was a centerpiece of the legal efforts to achieve racial integration in the United States, and by adding disability to that statute, Congress again endorsed integrationism as a basic goal of disability policy. The Americans with Disabilities Act, of course, represents the most comprehensive legal realization of Professor Tenbrook's goal of disability integration. The ADA, which celebrates its 25th anniversary this year, celebrated it this summer, July 26th. If you've worked at the Justice Department enforcing the ADA, as I have, you know July 26th is the crucial date because that's the date you have to announce all the big stuff because it's the anniversary of the statute. The ADA 25th anniversary this year, the ADA fundamentally promotes integrationism in several ways. We can start with the findings that Congress wrote into the statute. The law says that, quote, historically society has tended to isolate and segregate individuals with disabilities, that, quote, such forms of discrimination against individuals with disabilities continue to be a serious and pervasive social problem, and that, quote, individuals with disabilities continually encounter various forms of discrimination, including segregation. And the ADA's core operative provisions interact to guarantee people with disabilities access to all of the major institutions of economic and civic life on an equal basis. And they require those institutions to take affirmative steps in the form of reasonable accommodations to ensure that people with disabilities can act as full participants alongside the non-disabled. The ADA is premised on the following idea. The major institutions of society were designed without people with disabilities in mind, but people with disabilities have a claim in justice to demand that those institutions be designed with the understanding that people with disabilities are full members of society, just like anybody else, and can be expected to participate fully in those institutions as subjects with their own projects, choices, and independence, rather than as objects to be cared for. This basic idea, which comes straight from Tenbrook, underscores the statute's prohibitions against discrimination, its requirements of physical and program accessibility, and its demand for reasonable accommodations and modifications. It's the idea that Professor Tenbrook was the first to develop in legal theory in those articles in the 1960s. The ADA incorporates Professor Tenbrook's policy of integrationism in a more overt way as well. One of the key cases the Supreme Court's decided under the statute is its 1999 decision in Olmstead versus LC, which I know people in Minnesota have been struggling with and working with for a long time now, and have recently reached some important milestones in. In the Olmstead case, which has been aptly called the Brown v. Board of the disability rights movement, the court held that the ADA imposes an integration mandate, which requires states that administer services for people with disabilities to do so in the most integrated setting appropriate to the individual. And in the decade and a half since that decision, Olmstead has pushed states to tilt away from housing people with disabilities in custodial institutions and nursing homes separate from the rest of the community. Instead, states have begun to build up robust systems of services and supports that enable people with disabilities, all kinds of disabilities, to live in apartments alongside others in the community, to make basic life choices, and to spend their lives in the same activities in which everyone else participates. Recently, Olmstead has led states to abandon dead-end work and sheltered workshops and commit to providing supported employment services that enable people with disabilities, even very severe disabilities, to obtain meaningful, remunerative work in the competitive economy. My wife always makes fun of me when I use the word remunerative, but I think it's very appropriate here. Even outside of the Olmstead context, many of the key cases applying the ADA have guaranteed that people with disabilities get the anti-discrimination protections and accommodations necessary to participate fully, equally, and side by side with non-disabled persons in all of the key areas of everyday life, from attending court and other governmental proceedings in a case I litigated, Tennessee versus Lane, to patronizing stores and businesses of all types, to recreational activities like going to the movies or the ball game, which of course are things that everybody takes for granted, but that in the absence of access cannot be provided on an integrated basis to people with disabilities, patronizing casinos, going on a cruise, all of these things. These developments are a great vindication of Professor Tenbrook's work. So that's the last 25 years. The last 25 years, and even before, have been the age of integration for people with disabilities. And I don't want to suggest, as you in Minnesota certainly know, that the problems of segregation, isolation, and exclusion that Tenbrook highlighted and that the ADA attacked have been solved. Far from it. To be sure, the ADA and the legislation that preceded it has resulted in notable gains for Americans with disabilities. Buildings and programs are more accessible. Americans with disabilities are better educated and far more often educated in integrated settings than before. Those disabled Americans with jobs, by and large, have better jobs, and people with disabilities are a more full part of everyday life. If you compare the America of my childhood, I was born 45 years ago, to America today, it is a much more open society for people with disabilities. It is a society in which people with disabilities are far more integrated. And when I have foreign graduate students, whom I often have, who have disabilities, who come to the United States, even though we have many problems in the United States with compliance with the ADA, with continued inaccessibility, what my foreign graduate students tell me is that America is like an accessibility nirvana, that we are far ahead of the rest of the world, and it's a real success story. But the proportion of Americans with disabilities who are not in the workforce remains stubbornly high. Businesses still fail to comply with basic requirements of the ADA, as you will know if you go down any main street in America, and prejudice and discrimination persist. I don't think it's time to inter Professor Tenbrook's principle of integrationism. The principle is still vital, but it may be time to build on it and go beyond it. Many of the issues that occupy the disability rights movement today, and we'll get to one that occupies the disability rights movement literally today, and will increasingly occupy the disability rights movement in the years to come, are not principally about integrationism. Yet I think Professor Tenbrook's work gives us an important guidepost for thinking about those issues. These insights come not from Professor Tenbrook's disability law work, but from his extremely important scholarship on the Equal Protection Clause. Now, if you're a lawyer of a certain age, and I'm just at the tailing edge of this group, you probably spent formative time in law school working through Professor Tenbrook's 1949 article with his colleague Joseph Tussman on equal protection law. That piece, with its intense and crisp analytic discussion of the problems of legislative classification, complete with Venn diagrams, and I remember, every T is an R. If you've read this, it's like impossible to work through. But it structured how generations of lawyers, law professors, and judges understood the basic concerns of equal protection doctrine. But in some ways, Tenbrook's more important theoretical contribution to equal protection scholarship was his 1951 book, The Anti-Slavery Origins of the 14th Amendment. In that book, Professor Tenbrook conducted an extensive old-school originalist examination of where the 14th Amendment came from and what its drafters understood it to mean. As the book's title makes clear, he found the amendment's origins in the constitutional theories developed by abolitionists and anti-slavery activists before the Civil War. These activists included Theodore Weld, Henry Stanton, Salmon Chase, Alvin Stewart, and many others. And I taught today in class, actually, a case Alvin Stewart argued in the New Jersey Supreme Court, State versus Post, in which he unsuccessfully argued that the New Jersey Constitution eliminated slavery. Tenbrook persuasively describes how the theories developed and articulated by these theorists, although they did not prevail before the Civil War, were central to the way that the congressional drafters and supporters of the 14th Amendment, notably Congressman John Bingham, described and defended the 14th Amendment. Professor Tenbrook argues that a crucial aspect of the anti-slavery constitutional theory was the concept of the quote-unquote protection of the laws, which was in turn the root for equal protection of the laws. The concept was not about trying to ensure that legislative classifications were reasonable, rational, or sufficiently closely connected to sufficiently important interests. All this levels of scrutiny stuff, that's not what it was about. Rather, it was about something much more elemental even than legislative classification. It was about the right, which the anti-slavery activists considered a natural right, to have the government protect individuals against the depredations of other individuals. The anti-slavery activists derived this natural right from a social contract analysis similar to that of the Declaration of Independence. Why do people give up their liberty to submit themselves to the authority of governments? They do so in order to achieve protection for their basic interests, life, liberty, and property in the Lockean sense, life, liberty, and the pursuit of happiness to Jefferson. To secure these rights, the Declaration of Independence said, governments are instituted among men, and because we all give up our liberty in order to obtain protection of our personal security and other basic interests, the government has an obligation to hold up its end of the deal, to protect us when other private individuals threaten those interests. Equal protection of the laws was thus an affirmative guarantee of state protection. That's Tenbrook's argument for how the anti-slavery theorists thought of the natural right to protection of the laws, which was incorporated in their understanding of the 14th Amendment. Tenbrook argues that this, far more than an effort to regulate legislative classification, is what the Equal Protection Clause was originally intended to be about. And I can give you quotes, but I'm not going to. You read the thing when it's published. There will be quotes in there. Now, I'm not saying that Tenbrook's is the right way to read the Equal Protection Clause doctrinally. I'm skeptical enough about what the concept of the right way to read a constitutional provision that I don't think I would ever say something like that. But I do think that Professor Tenbrook's analysis brings to the fore some very important aspects of constitutionalism in a just society that our dominant focus on the negative Constitution suppresses. And I think that the work of progressive scholars like Robin West, who've drawn on Tenbrook's argument to develop a constitutional theory in which the state has important affirmative responsibilities to the people, is extremely attractive in many ways. But I'm not going to adjudicate the question whether Tenbrook is right about the original intent behind or the public meaning of the Equal Protection Clause. There have been historians who have challenged Tenbrook's conclusions. There have been other historians who have bolstered them. Nor would I say that Tenbrook's abolitionist-derived reading is in any way the dominant understanding of the 14th Amendment today. I mean, obviously, that's the whole point of the negative Constitution phrase. Current doctrine recognizes little in the way of affirmative constitutional obligations to protect persons against each other. There's some hint of Tenbrook in Romer versus Evans, where the court says, a law declaring that in general it shall be more difficult for one group of citizens than for all others to seek aid from the government is itself a denial of equal protection of the laws in the most literal sense. And when a state offers protection to some and not others, the dominant understanding, even today, requires equal protection scrutiny of the differential treatment. But current doctrine imposes important limitations even there. So one of the core cases that Professor Tenbrook gives is a case where states aren't providing the equal protection of the laws, and he says the original understanding was to empower Congress to step in and provide the protection that states were not. Yet in United States versus Morrison, the Violence Against Women Act case, that's exactly what the court held that Congress may not do under its affirmative power under the 14th Amendment. So I can hardly say that Professor Tenbrook's abolitionist understanding reflects the law today. And I'm not going to argue that Professor Tenbrook's understanding should be the law under the 14th Amendment. I just want to explore what the abolitionist understanding of equal protection has to tell us about the future of disability rights law in America. And as I'll argue it in the rest of my talk today, in my remaining 7 minutes, goodness, I think many of the issues that are coming to the fore in disability law and policy are issues that are best addressed by employing Tenbrook's understanding. If the first 25 years of the ADA were driven by the effort to codify Tenbrook's integrationist principle, I argue that the next 25 years will be as much about the effort to heed Tenbrook's equal protection insights. And I have 3 things I want to talk about. We'll see how long I talk about each of them in the context of my now 6 minutes probably, that seem especially important to me today. One is hate crimes against and abuse of people with disabilities. 2 is police use of force against people with disabilities. And 3rd is the continuing controversy, and this is what I mean by something that occupies people even today, regarding the possible legalization of physician-assisted suicide. As I was flying over here, I read Jerry Brown in California announced that he was signing the bill legalizing assisted suicide in California. So really today. So first, hate crimes. So people with disabilities are frequent victims of violent crime. The rate of violent victimization, according to the Bureau of Justice Statistics, against persons with disabilities was more than twice the age-adjusted rate for the persons without disabilities. Persons with disabilities experienced 1.3 million violent victimizations in 2013, which accounts for 21% of all violent victimizations. And there are a lot of reasons for this. A crucial one is that perpetrators of violent crime specifically target individuals with disabilities, whether out of animus or because of the perception that disabled persons are particularly vulnerable victims. When adults with disabilities receive services in custodial settings, such as state institutions, nursing homes, and group homes, they're especially vulnerable to violence and abuse. That's because the institutional setting places individuals with disabilities in close proximity to caregivers who may not be well screened and monitored, and because the separation of institutions from the community limits opportunities for outsiders to see and stop what's going on. And if you look, I'll cite in the written work a number of examples of this, up to and including reported rapes, serious assaults in thousands of cases. Children with disabilities are subject to disproportionate abuse and violence in a variety of settings as well. Youth with any disability, according to the National Crime Victimization Survey, are more than 2 times more likely to be exposed to sexual assault as other children. And a 2011 review of the literature found that children with disabilities are at significantly greater risk for physical maltreatment and neglect by their parents and caregivers. Far too often, that has the most devastating consequences. So the Autistic Self-Advocacy Network, a terrific organization, reports that since 2010, over 70 people with disabilities have been murdered by their parents. These parents often claim they were acting in their children's own interest to put an end to their quote-unquote suffering. These statistics obviously represent a major threat to the equality of people with disabilities. They also, I would argue, present a problem of equal protection of the laws. Where matters of such basic personal security as the freedom from abuse, violence, rape, and murder are concerned, we are at the core of the matters with which, according to Professor Tenbrook, the 14th Amendment is concerned. Heeding the abolitionist understanding of the 14th Amendment, the state has an obligation to protect individuals with disabilities against these bodily invasions. And it has an obligation to provide equal protection to individuals with disabilities, which is to say no less protection than the state provides to non-disabled victims of similar violence. But the state has failed in this obligation. The legal system has generally not taken violent crime and abuse against individuals with disabilities as seriously as it's taken similar types of violence against non-disabled individuals, although there are some encouraging signs. The Shepard-Byrd hate crimes law, a law President Obama signed in his first year in office, provides federal criminal penalties for discriminatory violence against individuals with disabilities, and the first ever prosecution brought under that law involved a shocking act of violence, of abuse, and even branding perpetrated against a Native American young man with an intellectual disability. This is an important step to pass this law and bring prosecutions like that one, but it's not enough. Ample evidence demonstrates that police, prosecutors, and jurors frequently disbelieve reports of violence when they're made by individuals with disabilities, and this disbelief, in turn, encourages victimizers to select disabled individuals as their targets. So does the failure of law enforcement to penetrate the closed, out-of-the-way, segregated settings in which too many people with significant disabilities are forced to spend significant portions of their lives. These acts of violence implicate the basic security and even the life and death interests of individuals with disabilities. Disability rights advocacy must urgently focus, I would argue, on providing the equal protection of the laws that's necessary to prevent and punish them. Let me talk about my second example, which is police use of force against people with disabilities. Now, the Black Lives Matter movement has recently focused much needed attention on unnecessary and undue police use of force against African Americans. But what's often lost in the discussion is that many of the victims of the unnecessary use of force, including many of its African American victims, I mean, many of the things that Black Lives Matter is specifically talking about, are individuals with disabilities whose disabilities play an important role in leading to the use of violence by police. The most common scenario involves individuals with mental illness. A recent review of the literature by the ACLU concluded that approximately half of fatal police encounters involve persons with psychiatric disabilities. That's half of all fatal police encounters, not just those involving people with disabilities. A comprehensive review of case reports by the Washington Post over the summer found a smaller number, but still a strikingly large number. In the first 6 months of 2015, the Post found police in the United States had shot and killed 462 people, 124 of whom, or over a quarter, were individuals who, in the Post's words, were in the throes of mental or emotional crisis. Now, because the newspaper's analysis focused only on police shootings and shootings of those who expressed suicidal intentions or for whom police or family members identified and confirmed a history of mental illness, the Post acknowledged that its approach likely understates the scope of the problem. Even so, the Post's findings were striking. In the cases in which police had used force against individuals with mental illness, they often were not acting in a way that was violent. They were carrying blades, such as knives or machetes, even though only 3 police officers have been killed by a bladed weapon in the last 10 years. Perhaps most strikingly, in 45 of the 124 cases, the reason the police were called in the first place was to help the individual obtain mental health treatment. But rather than provide the protection for which they were called in, these police ended up fatally shooting those they were initially supposed to be helping. Now, is that because the police are bad people? No. Does it mean the police are intentionally discriminating against individuals with mental illness? Not necessarily. But it does reflect a denial by the state of the equal protection of the laws. It's the state, after all, that puts police officers in the position of being the frontline responders to people in mental health crisis. Effective responses to such crises do not involve law enforcement in the first instance, but instead involve trained mental health professionals, social workers, psychologists, psychiatrists, as well as peers who are trained to de-escalate and intervene appropriately. It's notable, and should be a model, that the Department of Justice in its ADA settlements over the past 5 years has treated mental health crisis services as a key component of a state's compliance with its Olmstead obligations. These settlements have required states to implement a number of types of crisis services, including 24-hour crisis hotlines, mobile crisis teams staffed by mental health professionals, and crisis drop-in centers, beds, and apartments staffed by peers for times when people briefly need residential services. These requirements create an integrated mental health crisis system that focuses on ensuring that those who go into crisis can retain their ties to the community to the extent possible, and that crucially does not make police the primary entry point into the mental health system. Adoption of reforms like these would significantly reduce the occasion for risky encounters between law enforcement officers and individuals with mental illness. They wouldn't eliminate those encounters entirely, but that points up another failing of our current practices. Despite the successful efforts of a number of forward-looking police departments around the country, officers, by and large, still do not receive appropriate or sufficient training for dealing with individuals who are experiencing mental health crises. And, if you saw John Oliver last night, which I watched this morning, he has a terrific segment on this. I mean, it's actually one of our best journalists in America is a British comedian, interestingly enough. It's a really good segment. You should watch it. I mean, it actually is the most factual segment I've seen in any journalistic enterprise about mental health in America these days. The Washington Post reported that although new recruits typically spend nearly 60 hours learning how to handle a gun, they receive only 8 hours of training to de-escalate tense situations and 8 hours learning strategies for handling people with mental illness. And even when they do receive training in how to address these situations, the Post reported, that training tends to be counterproductive. It encourages officers to establish authority and control as a first principle, which is an approach that will typically escalate rather than de-escalate a mental health crisis and predictably lead to the deadly results we've seen. Now, last term in City of San Francisco versus Sheehan, the Supreme Court granted certiorari to decide whether the ADA applies to police uses of force against people with disabilities. The court ultimately avoided the question, but its opinion suggests that many justices seriously entertain the proposition that the ADA does not apply to such uses of force, and that a majority of the court might well endorse that proposition in a case in the future. Such a position, it seems to me, would disregard the plain text of the ADA, which covers anything a state and local government does without any textual limitation. It would also disregard the court's own unanimous decision in the 1998 Yeski case, which held that the statute's general language unambiguously applies to the operation of state prisons, and which refused to read any unexpressed exception into the broad statutory text. But even more than that, for my purposes today, a decision to exempt police uses of force from the ADA's coverage would represent an abdication of the obligation to guarantee the equal protection of the laws in Professor Tenbrook's sense. I'm therefore somewhat relieved that the court avoided the issue, though I find the suggestions in the court's opinion worrisome. Now, you might see a tension between my first example and this one. Earlier, I was arguing that the failure to provide aggressive policing and prosecution denied equal protection of the laws to individuals with disabilities. Here, you might say I'm arguing for the opposite. I'm arguing that too aggressive policing denies equal protection. So can these two positions coexist? And I would argue yes, and that the two positions have in fact coexisted since the development of the abolitionist constitutionalism that Professor Tenbrook elaborates in his work. Abolitionist constitutionalists argued that the brutality of the state and the failure of the state to intervene to stop the brutality of private parties were two sides of the same coin. The same theme appears in the work of Professor Tenbrook's contemporary Gunnar Myrdal, whose An American Dilemma treats police brutality and the lack of effective policing in black communities as components of the same problem. And it's a central theme in President Truman's groundbreaking civil rights report, To Secure These Rights, issued in 1947, which I felt compelled to mention in Minneapolis because, of course, it was that report, To Secure These Rights, that was the basis for the civil rights plank in the 1948 Democratic National Convention that then Minneapolis Mayor Hubert Humphrey became famous around the country by advocating. I argue that we should apply the same insights of the abolitionist constitutionalists of Tenbrook, of Myrdal, of Truman, and of Humphrey to the disability context. All right, so let me talk about my third example. I know I'm a little bit over time, but I'm still going to talk about it. So, because I have you here, you can always leave. But so, unlike the others, it's not strictly a criminal justice issue, but it's very much in the news, as I've said, and that issue is the legalization of assisted suicide. In its 1997 decisions in Washington v. Glucksberg and Vacco v. Quill, the Supreme Court upheld state laws in Washington State and New York State banning physician-assisted suicide. And although the large number of separate opinions made the court's precise rationale unclear, and there's continuing dispute about what exactly the court held, the court plainly held, at least in the circumstances of the cases before it, that the Washington and New York statutes did not deny 14th Amendment rights to due process and equal protection. And disability issues were central to the litigation and decision of the Glucksberg and Quill cases. When the New York Task Force on Life and the Law recommended in 1994 that the state retain its prohibition on assisted suicide, it highlighted two key risks that legalization would pose to people with disabilities. First, it noted that many people who commit suicide are depressed or have other psychiatric conditions, yet those conditions are poorly diagnosed and treated. Many others, it noted, have chronic pain but do not have access to appropriate pain treatment. Allowing assisted suicide, the task force concluded, thus would predictably lead to the unnecessary deaths of people with these conditions, deaths that these individuals would not choose if appropriate treatment were provided for them. Second, the task force concluded that people with disabilities that are costly to treat would face subtle coercion from insurers, doctors, family members, or even their own sense of obligation to family members to end their own lives. And when the Clinton administration filed a brief in support of the prohibition of assisted suicide in the Quill and Glucksberg cases, it highlighted these disability issues. And I was working at the Department of Justice at the time and remember the very anguished debates that people had within the Justice Department about these issues. The court, in its Glucksberg opinion, also highlighted these disability issues. And indeed, Chief Justice Rehnquist's opinion for the court in Glucksberg makes an argument that to me sounds rather clearly in Professor Tenbrook's equal protection theory, though he doesn't cite Tenbrook. And I'm going to quote him. He says, "The state's interest here goes beyond protecting the vulnerable from coercion. It extends to protecting disabled and terminally ill people from prejudice, negative and inaccurate stereotypes, and societal indifference. The state's assisted suicide ban reflects and reinforces its policy that the lives of terminally ill, disabled, and elderly people must be no less valued than the lives of the young and healthy, and that a seriously disabled person's suicidal impulses should be interpreted and treated the same way as everybody else's." Now hold on to that idea, because I think that's crucial to understanding how Tenbrook's insights apply here. Since Glucksberg and Quill, advocates of the legalization of assisted suicide have proceeded on a state-by-state basis. They've obtained passage of laws in Oregon, Vermont, and Washington State, and now today in California. They've obtained favorable judicial decisions in Montana, and everybody expects very soon in New Mexico. And much of the public debate surrounding these developments has taken a form that is very familiar from the politics of abortion rights. Defenders of the legalization of assisted suicide argue in terms of individual liberty, in terms of the right to make choices that are fundamental to directing one's own life course and authoring one's own life story, and the right to control one's body. Most of the opponents whose voices are heard in the media argue that assisted suicide denies the sanctity of human life. Not surprisingly, the media tends to portray fights over the assisted suicide issue as but another battle in the abortion wars. Now, there's a degree to which this portrayal is accurate. Many supporters of the legalization of assisted suicide do see their position as congruent with, and perhaps even required by, their support for the right of a woman to choose to have an abortion. And many opponents, and I suspect this includes many in the audience today, oppose the legalization of assisted suicide based on a view that is a view that they would consider a pro-life view that accords with their anti-abortion politics. But Professor Tenbrook's analysis points the way to a different argument against the legalization of assisted suicide, one that scrambles the traditional lines of abortion politics. It's an argument that many disability rights activists who are avowedly pro-choice have repeatedly made, though it's one that has struggled to be heard in the media narrative. The basic argument is this, and it's basically what Rehnquist said. In our society, when people seek to terminate their own lives, the dominant societal response is to try to stop them from doing so. We have suicide hotlines. We place people under suicide watch in jails and hospitals, and we may even civilly commit people or otherwise severely restrict their liberty to prevent them from killing themselves. But when a person has a disability, advocates of assisted suicide believe the desire to kill oneself is understandable. They thus argue for withdrawing the protection of the state laws that generally prohibit third parties from aiding people in ending their own lives. This reflects a negative and stereotypical or prejudiced view of life with a disability that's one that most people with disabilities do not hold. And certainly, the overwhelming majority of people with disabilities after an initial period following acquiring a disability do not hold it. And it also constitutes a denial of equal protection of the laws in Professor Ten Broek's sense, as Chief Justice Rehnquist all but told us in Glucksberg. I would argue, therefore, that if one takes Professor Ten Broek's understanding of equal protection seriously, one should oppose the legalization of assisted suicide, and that's true whether one holds to a general anti-abortion politics, as I suspect many here do, or instead supports abortion rights, as I do. And I appreciate you inviting me here, because I've been criticized by people on this stage for doing so. And so I very much appreciate that. And I think this, again, is one of the central issues for people with disabilities and disability rights today, because it's about the degree to which we value the lives of people with disabilities. Now, Professor Ten Broek's principle of integrationism, I will conclude, set the agenda for the first 25 years of the ADA, and it is still a vital principle. But the life and death issues that I've discussed today are exceptionally important right now. And those issues are best addressed by a different principle, one also developed by Professor Ten Broek, which is the abolitionist understanding of the equal protection of the laws. And I would argue that should help set, alongside the integrationist principle, our agenda for the next 25 years. So thank you for staying. Thank you for listening to me. And I look forward to interacting more with you.